Hello, and welcome to another webinar by the School of Law of the University of Central Lancashire in Cyprus. My name is Nadia Kornioti, and today I'm going to speak to you about refugee law in Cyprus, the EU, and the world. What I am trying to do today is give you an overview of the different rules that exist concerning the issue of refugee law. We are all familiar with many of the terms relevant to this area of law. However, we rarely take the opportunity to think and discuss what the different terms mean. So I am hoping to give some clarity on the matter. Let me start first with what a migrant or who a migrant is. Migrants, in simple terms, are people that have left their country of origin, where they were usually born and raised up, and they have moved to a different country for an extended period of time. This can be done for all sorts of reasons. However, the most frequent among them is economic migration. Economic migrants are people that move from their country to another country in order to obtain better jobs, better income, and better opportunities professionally. Another reason is when people move from one country to the other in order to undertake studies in a foreign institution. So if you or somebody you know has left your country to study in a different country, then you're also a migrant for that period of time. Another reason could be family. If members of your family live in a different country and you want to join them, or if your partner comes from a different country, so you decide to move with them in their own country, or if the two of you decide to move in a third country, as long as you can stay together. Now, how many? Today, according to the International Organization for Migration, the UN agency dealing with migration matters, there are 272, they were in 2019, 272 million migrants. Though that is a huge number, if we put it in perspective, in a percentage, then it's only a 3.48% of the global population. I would like to clarify two misunderstandings that usually exist on issues of migration. First of all, is that not all migrants are poor, and they don't always move to a richer country for higher salaries. A CEO of a big multinational company that moves to another country, to a country other than their country of origin, they are also a migrant on the same terms. They need to apply for a visa, they need to obtain a permit, and they need to a permit to work and a permit to reside in the host country. Probably the only difference is that usually we're not, society doesn't discriminate so much against migrants that have a higher status in society. Secondly, the other misunderstanding I would like to refer to is that people usually think that people migrate only across borders. However, internal migration is equally important, especially in big countries like, let's say India or Canada. People are very likely to leave their own region, the region of their country where they grew up, and go to another city or a village or area where they will have better opportunities to live there. Now, let's turn to refugee law. Within the broad group of migrants, there are some people that are forced to leave, whereas a migrant takes a conscious decision that they prefer to move in another country. Refugees leave because where they are in danger. So there are many reasons for forced displacement. We have usually we refer to armed conflicts. However, and this is what we usually have in mind, but this is an equally important picture to have in mind, because people might decide to move from one country to the other because of environmental disasters or because of drought, and they don't have access to important resources such as water. Another reason is because people might be persecuted because they believe, they hold certain beliefs, or they belong to a specific group of people. Now, by the middle of 2020, there were about 80 million forcibly displaced people around the world. People that have left their own country or their own village or their own city because staying there would mean that their life was in danger. Out of these 80 million people, 45.7 million, that's more than 50%, are internally displaced people, which means that they have never really moved out of the boundaries of their own country. The number of refugees, of people that have crossed international boundaries and have entered other countries in search of protection, are 26.3 million by the middle of 2020. A smaller number of 4.2 million people are asylum seekers. An asylum seeker is somebody who has applied for international protection. They claim they are refugees, but the authorities of the host country has not yet given them an answer on whether their application is accepted or not. To have a better global view of the situation, I here present you the top 5 countries of origin and the top 5 host countries around the world. The Syrian Arab Republic is the country with most refugees around the world at the moment, with 6.6 million persons. Obviously, after a whole decade of a civil war, the situation there is not bearable, and many people have decided to leave their country and seek protection beyond the Syrian borders. Now, in terms of host countries, we have on top Turkey, followed by Colombia, Pakistan, Uganda, and Germany. You can see that Germany is only 5th, and that is the country with most refugees within the European Union. As I am talking to you from Cyprus, I think it's important to also look at the Mediterranean. The Mediterranean route is one of the most important routes for migrants from North Africa and the Middle East towards Europe. Until the middle of November 2020, there were 84,340 arrivals through this route. You can see from the map that the country that has received most people was Spain, followed by Italy, followed by Greece. It is important to mention that these numbers don't include the numbers of people who disappeared and or most probably lost their life in the Mediterranean Sea. So we're talking about a huge humanitarian disaster that remains largely unaddressed. Now let's look a bit at the international legal framework. Refugee law developed out of the experience of the Second World War, where people realized that in times of war, there is a need for a framework that will allow people to travel to safer and seek refuge in a safer country. So when the United Nations was established in 1945, and 3 years later, the member states voted in favor of the Universal Declaration of Human Rights, the Universal Declaration included an article recognizing the right to seek and enjoy asylum in other countries. This, however, was a simple statement, so countries looked for a legal framework that would establish the duties and the obligations of the relevant parties. For this reason, in 1951, they passed the International Convention relating to the status of refugees, which was then supplemented with an additional protocol, the Additional Protocol of 1967. These two documents together are the core legal framework at international level on refugee law. According to Article 1 of the 1951 Convention, a refugee is any person who is outside their country of origin because they are seeking protection on the basis of race, religion, nationality, membership of a particular group, or political opinion. It is important to also note the reference to well-founded fear of persecution. This fear that you are in danger has to be personal. You have to prove in order to be a refugee that you yourself are in danger because of who you are and on one of these 5 bases: race, religion, nationality, membership of a particular group, or political opinion. During the same period, we saw the establishment of the UN Agency for Refugees, the Office of the High Commissioner for Refugees, which until today is in charge of monitoring, assisting, and offering expertise on issues relevant to refugee law. Now, let's put everything in perspective. The categories of forcibly displaced people are the following. We already referred to refugees and the definition of refugees under the 1951 Convention. Before somebody is a refugee, however, needs to make an application to the host country. During the period they are waiting for an answer on their application, these people have the legal status of an asylum seeker. If people have left their region, their own region within their own country, and they have moved to a different region within their own country, they are internally displaced persons. Internally displaced persons are afforded many of the rights that refugees have, and they are equally protected. However, since they remain within their own country, their own country has responsibility towards them, and their policies relevant to internally displaced persons are slightly different. For this reason, this new term, IDPs, or internally displaced persons, was employed in the early 1990s in order to separate them from refugees that are crossing international borders and find themselves in much trickier situations often. The last category, the 4th one, I have put in brackets only because this is not a legally regulated category. In fact, undocumented or irregular migrants are people that have left their country without their documents. Potentially, very often, they are refugees. However, their identification documents were either lost on the way, they may have been stolen, and for one reason or another, they arrive without being able to prove who they are. This is an increasing problem, however, due to the fact that many people actually are trying to leave to protect themselves. Even if they cross a border illegally, they are not considered illegal persons. It's just that their status is not legally regulated in the meantime until they manage to regulate their status. Now, let's move to the European Union framework. In 2019, the EU hosted some 2.6 million refugees. That is only 0.6% of the total EU population, which is around a bit more than 450 million people. The European Union decided that it would be best if asylum issues are being regulated centrally. For this reason, in 1999, the European Union, with its member states, established the Common European Asylum System, under which allow the relevant legal instruments that regulate the matter of asylum and refugee law. You can see here the Asylum Procedures Directive, for instance, which regulates the different procedures that need to be followed by the authorities of each member state. The Reception Conditions Directive, which puts the standards relevant to the minimum standards for accepting and taking care, offering services to asylum seekers upon arrival. The Qualification Directive, which puts down a framework within which member states are to offer or not international protection to people, the Dublin Regulation, and the Eurodac Regulation. The last two, they're not directives, so they don't offer a framework, but rather they offer specific rules that are binding on all member states. The Dublin Regulation is a regulation the regulation providing the rules for which member state is going to be responsible for every asylum seeking application. The basic rule with the Dublin regulation is that people need to apply for asylum in the first country of entry within the European Union. So if somebody starts walking from Syria to Turkey and then with a boat they cross into Greece, which is a very, very realistic scenario, even if they don't want to apply for asylum to Greece, but they would rather apply for asylum in Sweden, they don't really have an option because Greece is the first country of entry. Now you will wonder, how can they check whether a person got in through Spain or Greece or Cyprus, let's say? This is where the Eurodac regulation gets in, because upon arrival, people are required with their asylum application to also give samples of their fingerprints. And this is stored in the Eurodac database, which is accessible throughout the European Union. So if that person is found, let's say in Portugal, but they entered the EU through Spain, they will be sent back to Spain for their application to be processed. Of course, the system was very problematic and has led to many, many debates within the European Union. At the time of recording this video, it's worth mentioning that a new reception conditions directive is being debated and a qualification regulation. This is because at the moment, the way the system works, maybe some people that fulfill the criteria to be refugees in, let's say, Germany, are not fulfilling the criteria to be refugees in some other member state. So there is an inequality in the way that the different applications of different people are being handled. So if we have a qualification regulation within the European Union, then we will make sure that the same criteria apply for the same level of protection awarded to people. You might have noticed that I don't speak about refugee status anymore, but when I talk about the EU, I refer to international protection. This is because there is two levels of protection afforded under EU law. The first of them is the status of recognized refugee under the definition given by Article 1 of the Geneva Convention of 1951, with its emphasis that there is a need for well-founded fear of persecution, making the danger very, very personal to the applicant. And then there is also the possibility of giving to somebody subsidiary protection. Subsidiary protection is given to people who are not personally persecuted, but they still come from a dangerous country like, let's say, Syria. And if you return them there, they will still face a threat to their life. The difference between the two is that whereas a recognized refugee has their status for as long as they want to, and the host country cannot withdraw their protection under normal conditions, with the subsidiary protection, the host country retains the right to withdraw the protection if they think that danger in their country of origin is now gone. So if there is a peace treaty, let's say, in a conflict area, and the hostilities are finished, then this area, this region, this country will be considered safe, and people will be, if they're under subsidiary protection, then they will be sent back. So the EU Pact on Migration and Asylum was announced in September 2020. It consists of 500 pages of proposals by the European Commission on issues relevant to migration and asylum, including integration and border management. While I'm not going to get into the details, it's important to be aware of it, because it means that in the next few years, we will see major changes in the already functioning system of international protection within the European Union. Now let's turn to Cyprus. Both international and the EU framework I have already mentioned above is integrated into domestic Cypriot law under the refugee law of 2000. Contrary to countries that have traditionally accepted refugees, such as Sweden, Germany, and the UK, which is not anymore a member of the EU, Cyprus didn't have its own centrally regulated asylum system, and it had to establish one as a prerequisite to becoming a member of the EU in 2004. That's why refugee law in Cyprus it comes relatively late, only in the year 2000. For the last 20 years, this law has been amended numerous times. It has almost an equal number of amendments today because it continuously adapts to the new rules that derive out of EU law. While I'm not going to go into the details of refugee law, I would like to refer to the main principles deriving out of refugee law at international, EU, and domestic level. The most important principle is the principle of non-refoulement. This is a rule under international law according to which a country is not allowed to send the person back in their country of origin if their life there will be in danger. This is a customary rule in the sense, which means that there is no need for a country to sign a treaty. It's a rule binding every country, every state around the world. The other important principle is the principle of non-discrimination. You cannot treat people of some category more fairly than people that in another category. This is binding also the national authorities that are handling asylum cases. There is also the principle of fair treatment by the government's officers who are handling such cases. They need to treat everybody with fair and equal treatment. And then there is a principle of ensuring family unity. The principle of ensuring family unity asks that people that belong to the same family are not being separated. For this reason, children need to stay with their parents and spouses need to stay together throughout the procedure. There is also a need to have available information in the language understood by the applicant at all times. Usually, information is available in the main languages used. Very often, these are English and French, also in written form. For languages that are less often used, then the authorities need to make sure they will find an interpreter that is going to assist them and translate in the process of all administrative procedures. Last but not least, I would like to refer to the importance of recognizing vulnerable persons. Vulnerable persons can be unaccompanied minors, meaning people under the age of 18 who are traveling on their own and they apply for asylum on their own. They can be victims of human trafficking or people with disabilities or victims of torture and other forms of violence, including female genital mutilation. The reason vulnerable persons need to be identified is because they probably have specific needs that need to be addressed, and they require additional support and protection by the host country. Whether that support is psychological or medical or of any other type depends on a case-by-case basis. For this reason, the evaluation of vulnerable persons need to happen for every single person applying for asylum. Now, during a period where there is a lot being said on issues of migration and asylum, it is difficult to give a conclusion. Obviously, the system is there to protect the weakest party. It's our responsibility to be well informed, to pay attention, and not allow false information to be spread around. People moving within and out of their country is a persistent phenomenon in human history. It sometimes becomes more intense, like in the last few years, and sometimes lessens in intensity. However, it is always present. So to ensure a fair and equal treatment of all is a responsibility of every legal system.